Hi, I'm John Counsel. I'm a senior reporter with Texas Lawyer newspaper, and welcome to the January 5th, 2009 edition of Reversed and Remanded. It's our first edition of the year, and my guest today is Steve Malin. Steve is counsel at the Dallas office of Sidley Austin. He's a patent attorney, and I've asked Steve to come over and talk to me about a huge case that just came out of the Federal Circuit in regards to venue and where you can file and where you can get out of the Eastern District in particular. This is a patent case that was filed in the Eastern District before Judge Ward, and I guess the defendants in this case decided that they didn't want to be in the Eastern District because the product really didn't have much of a connection there. So they mandamus to Judge Ward, and they won at the Federal Circuit. And the reason this is such a big deal is this has happened before in Judge Ward's court in a products liability case called In re Volkswagen, where the Fifth Circuit essentially decided the same thing. And the Federal Circuit used the language and reasoning in the In re Volkswagen decision very liberally to arrive at their conclusion. And Steve, I guess my first question for you is, what's going to happen to patent litigation now that it's easier for the defense to get out if they want to? I mean, is it going to really decimate patent litigation in the Eastern District?
Well, I think the first thing that's going to happen is the defense counsel are all going to check their pleadings to make sure that they pled a venue problem. Right. Okay? And those that have, I would agree, are going to look very closely at whether there are any venue facts that are pled in Texas, and look very closely, for instance, at witness lists and disclosures to see if any connection with East Texas has been pled. Right. And if not, then they very well may get a copy of the motion to transfer venue filed in the TS Tech case. Although it's interesting to note that that was actually filed and decided before the Volkswagen and Bank case. Yeah. And that was one of the disputes on appeal to the Federal Circuit was, hey, we should have let the district judge take a look again. Right. Because there was this change in the law. But the Federal Circuit said, well, no, there was not this change in the law. Okay. So we're going to presume that the judge would have decided it the same way. Right. Little unusual for a mandamus case to permit that, but it is what it is. It is. And, you know, I've always wondered, is venue that big of a deal in patent cases where you're most of your witnesses are going to be of the expert witness variety? The product is assumed to be sold all over the United States. So does it really matter where you litigate these cases? There are two levels to your question. First is the emotional level. And it is believed, and we can see this by the popularity of the Eastern District of Texas, that there is some mystique to suing people in Texas. Right. The belief being that people that are far away from Texas, maybe in Asia or foreign countries, will believe that being sued in Texas is something different from being sued in the Northern District of California or Delaware. Right. So in that sense, there is this psychological or emotional effect. Maybe it exists, maybe it doesn't, but a lot of cases filed in Texas tell us that it is. The second question, which was really discussed in some of these cases and at the district level, is does it really make a difference where the case is filed? Because the discovery is all electronic. The witnesses, it's just as easy to fly 300 miles as it is to fly 1,000 miles. The evidence is spread all over the country. And that was the reasoning by the district court in some of these cases, that Texas is as good as anywhere else because there's no one logical place to have it. So both the Fifth Circuit, however, and the Court of Appeals disagree. Yeah. I'm pardon, the Federal Circuit Court of Appeals disagree. Right.
Okay, second issue. This week I wrote what I like to call the Slowpoke Report. I took a look at all of the pending cases and motions that all the federal judges in Texas had on their dockets. And usually, and this year was no exception, most of the judges have very little lingering on their dockets. They're all working hard and moving cases, but there's a few that get caught up for apparently reasons that are completely out of their control. And this year I was pretty surprised to find Judge David Folsom made the list. He's got a reputation as being very efficient. He's in the Eastern District. He has his fair share of patent litigation, and I talked to him, and he had 14, I believe 14 cases that had been pending for over 3 years, civil cases. And he told me, look, almost half of those were patent cases, and they had there was a request for re-examination of the patent by one of the litigants, and that pretty much shut the case down for about 14 months. They reopened it up, and then bang, it's on the Slowpoke Report. So, in patent litigations, does it slow down for reasons that are completely beyond the judge's control? Have you found that to be the case, Steve?
I think there's two aspects at play here. One is the Eastern District of Texas, including Judge Folsom, are victims of their own success, their own popularity. Right. They're now setting, for example, in Judge Ward's court, they're setting cases, trials 3 years after the case is filed. It also, these days, has become much more popular to stay the district court action and file a request for re-examination. Right. Or, for example, I have a case in front of Judge Ward right now that's stayed because there's a corresponding International Trade Commission case. Right. So, as we discussed earlier, once these other administrative issues are resolved, the case pops back up on the radar. Maybe it's 2 years from the date of filing, but nothing's been done. So it gets another 3 years, and through no fault of the judge, you have this case that looks old. But it is somewhat unique to patent cases that you have all these other administrative avenues you can take that might not be available in a products case. And we've written this before, that docket is so popular now, there's really no more rocket docket. It's because there's so many people that file there because, for whatever reason, the most common reason I hear is just the judges are experienced and they know how to look and deal with a patent case, but like you said, the victims of their own success. Okay, Steve, it's now time to put you in what I like to call the witness stand. I'm going to ask him some absolutely absurd questions and see what Steve has to say. Okay, first question, Steve. Have you ever watched a crappy late-night infomercial and thought, man, I hope somebody has patented the Flowbee home haircutting system because this product is genius? Actually, my thought wasn't so much did somebody patent it, but is somebody going to get sued on this? Does somebody else have this thing patented? Okay, good question. All right, question number 2. Should we just go ahead and rename the Eastern District of Texas Mandamus City? I don't think at this point. I think we'll wait and see if there is a real change in the way venue and even more importantly mandamuses are handled. There have been some criticism, especially in the Volkswagen cert petition, about the lack of deference and some other alleged problems with the way mandamus is handled. I don't know if it's Mandamus City yet, but I guess we'll wait and see. We're going to find out. All right. As 2008 has come to an end, I think I want to copyright last year by naming it the Year of Absolute Horror. Will you challenge that proclamation? Yes, I would challenge that proclamation. And we still have jobs, I guess, so maybe it's not too bad. All right. Steve, thanks for coming over. Thank you very much.